Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about class actions and vehicle defects. Cases that should have gone to the Supreme Court of Canada, but didn't. As a result of a number of vehicle recalls, there was a class action launched by individuals alleging that they were individuals who were affected by these vehicle recalls and deserved compensation for the defects in their vehicles. There were two groups of individuals, people who had received the recall notices and people who had not received recall notices but alleged the same defects existed in their vehicles. And a question arose as to whether or not they had standing to bring a class action lawsuit and whether they were effectively a class for the purposes of a class action lawsuit. And in the context of this case, it was also important for the court to consider whether or not people who were the subject of vehicle recalls could bring a class action lawsuit, because federal legislation allowing for motor vehicle recalls through Transport Canada to some extent limits the ability of individuals to sue where these companies engage in proper recall processes and limit the ability of individuals to bring these class action lawsuits. And this case, while on its face doesn't raise issues of national importance, it is still a case that deals with issues that do touch upon national importance, such as the extent to which federal or provincial governments can limit the ability of somebody to bring a lawsuit about harms that they have experienced by creating regulations that essentially oust the jurisdiction of the court, that essentially prevent lawsuits from being brought, or limit the manner in which lawsuits can be brought. We see this type of legislation popping up all across Canada now, with Alberta, with British Columbia, with the ICBC changes in BC, and governments are increasingly using their legislative power to prevent themselves or to prevent companies from being held liable for improper conduct. And the Supreme Court of Canada had an opportunity here to really get at the heart of this issue of essentially legislating away the power of the courts, especially when it comes to class action lawsuits, where there are potentially thousands of people who are put at risk in motor vehicle defect cases if the recall notices are not properly issued, or if the recall notices are perhaps unnecessarily issued to larger groups of people who are then caused harm as a result of not having their vehicles or not having access to their vehicles for periods of time. Unfortunately, the Supreme Court of Canada, I think, failed to see the connection between this particular case and a larger trend across Canada that is causing a lot of consternation in the civil litigation process. Hopefully, there's another opportunity for the Supreme Court of Canada to really constrain government ability to limit the ability to bring lawsuits against private actors and against government actors where their conduct deviates from the acceptable standards. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Reasonable Creative for putting together these videos. Please like, subscribe, and share with your friends.